We are going to end the conference today with a conversation, not an interview. In fact, nobody's here, so I'm not even going to call you Commissioner. I'm just going to call you Kim Roy. Kim, I want to welcome you to our conference. It was a bit of a roller coaster ride to get somebody from the Commission. We have a tradition started with Steve Hoffman that I would interview the chair every year, and obviously there's been some things going on, right, down there? Yeah. And so Chairman O'Brien could not attend with us, and then Sean Collins volunteered, and then he was told he could not attend with us, and you're the only one who has chutzpah to say yes, so we appreciate it. So Kim is the secretary and one of the 5 or 4.5 commissioners today. I don't know how many there really are. And why did you were appointed by Governor Baker.
Correct.
And why don't you tell us about why you took this position? Sure. How you got into deciding you wanted to get into cannabis.
Great, and thank you, Frank, for inviting me. 3rd time's a charm, right?
Yes, it is.
And I love this conference. I think this is my 3rd time attending. I've attended with former Chair Hoffman, was your fireside chat speaker. So thank you for inviting me. And I've been a commissioner now for about 2.5 years. I was appointed by former Governor Charlie Baker. I sit in the public health seat. For those that don't know, there's 5 commissioners. We all have a designated lane. Public health is the one I sit in. There's public safety. There's an industry seat. There's the chair, and there's a social equity seat. And based on my prior work experience, I had served over a decade at the Worcester County Sheriff's Office, where I oversaw community outreach. I was on the leadership team. I worked on reentry programs, helping to reduce recidivism. I saw up close the ravages of the opioid epidemic and what that had done to individuals and families. I helped co-author a curriculum called Face to Face that talks about the opioid epidemic and the myths and the facts of substance use disorder and incarceration. And myself and Sheriff Evangelitis, we brought that curriculum, which is very unique, to about 400,000 students across the Commonwealth to teach them about that. And this was mostly prior to legalization of cannabis at the time. Prior to that, I worked in the healthcare industry for Johnson & Johnson. So I think all of those things led Governor Baker to call me and ask me to, once former Commissioner Jen Flanagan moved on, to fill her vacancy. Great.
Well, we appreciate your service. I'm sure some days you question it, right? But you know, the landscape in Massachusetts, you know, the top line is growing, is fantastic. But when you really dig into it, you don't have to dig deep. This is a state where the industry is in distress. There are a number of businesses that are closing shop, that don't have the capital, that are truly struggling. Raised a lot of money, friends and family, right. Didn't really understand how sophisticated an industry this is. There is now, and my numbers may be off a bit, was it like 329?
It's a fluid list, yeah, but you're about
dispensaries, right. About 137 grows, another 300 applications in the queue, split about, I think, 167 dispensaries, 133 grows. This industry is got a lot of competition, a lot of issues, and plus the national issues, which affect everybody, obviously affect the state. But one of the things that's key to the success of an industry, any industry, that's highly regulated, is the boards and the committees and the commissions that regulate those industries. And the CCC, the Cannabis Control Commission, was established to do that. It was established to have communication, transparency, to be best in class. And you know, for years, I think that it grew very successfully under our predecessor's watch. Mr. Hoffman is here with us, and I'm not just saying that, I mean that. And today, as I said, it's just you and I talking here, there is, I won't say chaos, I'll say turmoil, I'll say disruption. There is clearly in-house fighting. I'm not speaking out of turn here. People know that in the industry. There's strife between the staff and the commission, between the staff and the executives, and obviously it's hurting the industry. You can't function, and governance is key to the success of any nascent industry. not here to talk about the lawsuit. Lawsuits you can't comment on. And I'm not Mike Wallace, so I'm not going to do that. But I do feel that as an commissioner that interfaces with the public, your perspective is very important, and it's also important for the industry to know how is the commissioner, how are they dealing with this? When are they going to get their X together, right? What can you say about that?
Well, and I understand there's a lot of fixation, as there should be with the commission, but I am focused on the work as my role as a commissioner. Now, having said that, I'd be lying to you if I said everything was perfect, so I wouldn't lie to you. It's been, public in the paper, as Frank alluded to. There is litigation, which I will not comment on. We've had executive session mediation, which has been public, which is to come to a common agreement between the staff and the commissioners, and we're not done there either. So there is work to do. Having said that, we have done a lot of work. For those who watched meeting last Thursday, the regulations for Chapter 180 got filed last Wednesday at the Secretary of State's office. And for those, and God bless you if you watch our meetings, because they are long, we had marathon sessions to make sure that we stayed on course and on time for HCAs, for municipal equity and suitability, and we got it done. And I'm really proud of the work. I was the regulatory lead along with Commissioner Concepcion on the HCAs. I'm really proud of the product that we put out there. It was very thorough and thoughtful. We met with a lot of stakeholders, and at the end of the day, and just, the expression, know your audience, I'd like to kind of, Frank, if I may, for 1 second. Is anybody here, a licensee has commenced operation? Anybody left here? Okay. Anybody SCP or EEA here? Okay, just so I know. Anyone in the provisional stage? Okay, or anybody in the queue altogether, in the beginning phases of the queue, just so I know. So, so I'm really proud of the work that we've done. If you watched meeting today, and you guys were here, so you probably didn't watch meeting, but we're focused on continuing the work, and we have had recently a lot of unanticipated vacancies. Our COO, Alyssa Stack, and she was tremendous. She recently, her last day was Friday. So that's a C-suite position. Adriana Leone, our CFAO, another C-suite position. Her last day was the Friday before. We're just in the process of hiring a general counsel. We're posted the deputy general counsel. We have a chair who is suspended and an ED who, he has his right, that's his right to take a leave. And so we have a lot of absences or vacancies. So what we did today, and you might not know, and maybe this is news to some of you, is we unanimously appointed our new CPO. She's only 6 weeks on the job, but she has 25 years experience, and she's a veteran, and we appointed her as acting ED today because, and per the comptroller's Massachusetts General Law 26, Chapter 1, we need a head of agency. We need for reporting purposes a head of agency. And Chapter 76 allows the commission, we have statutory authority in the absence of an ED to appoint an interim or an acting ED. And we exercise that authority today 4-0. So we are focused on your work. Despite all the distractions, I want you to know we are focused on your work.
No, I appreciate that. And I want to talk about the HCA and more particularity, and you really spearheaded that. And my read of the regs is you guys did do a lot of work, and there's definitely been improvement there. There's no question. I'm not taking that away from you. But you do know that the industry is concerned with what appears to be the lack of leadership, even though you're accomplishing these things. And we can always say, without digging into it anymore, you've addressed it. We all recognize it's happening. Hopefully there'll be a resolution soon, because you need a chair to lead any commission. Otherwise, you have continued in-house fighting amongst the chairs. I think you were an interim chair for a week or two.
I was an interim chair. As you alluded, Frank, on the elected secretary. So in statute, the commission has to elect a treasurer, as one of the commissioners as a treasurer, and another commissioner as a secretary. So I was unanimously elected as secretary, and it was precedent that the secretary would, in the absence of a chair, would chair the meeting. And so that's why I was, but we're in uncharted territory and uncharted waters. So I did chair that a couple of meetings I've chaired. About a half a dozen meetings in one capacity or another I've chaired.
So appointing the interim ED is, I assume that's Sean's position.
Correct.
And one could interpret that as more chaos or trying to plug a hole temporarily. It'll be interesting to see how that actually functions and where that's headed. So let's talk about navigating the CCC for the particularly for the operators and the consultants, attorneys in the audience. One of the constant concerns, complaints, whatever, is things still seem to take too long, particularly when you're dealing with change of control regulations. And it could be as simple as, okay, we're appointing a new CEO, we have to notify, that's got to get approved, et cetera. And the biggest item that always takes too long and time kills deals is when you're trying to sell. Now, there hasn't been that much M&A, so it hasn't been as big of an issue, but that's going to come back. And it can, in the past, before it took a year, then the CCC got it down to about 6 months. Today, I still think it's taking that 4 to 6 months duration period. Do you discuss this particular issue about navigating amongst the commission? How do we streamline the process in dealing with not just sales, but anything that falls into the purview of, you got to go through the licensing, you got to do a change of control application, things of that nature?
Well, the change of controls, they're like snowflakes. No two are exactly alike. I read them all. They're complicated, they're convoluted at times. You have parent companies, grandparent companies, they can be really complex. So, those are, they're not as easy as always adding one entity, removing one entity, adding one individual, removing one individual. And there's requests for more information. There's background checks that need to be done. So I know that the process has improved. As far as licensing, which used to take months, now takes 14 days to get a response from the commission on initial licensing. And we do work for that. And as a commissioner, I do strive for expediency and efficiency, but I don't want expediency to be at the cost of doing things accurately. And, so in transparency, as a commissioner, I always say sunshine is the best disinfectant. In the HCA regs, for those that have read the new regs, there is a sunshine clause. That's me. I insisted we have that. So we bring the more information we can give you in a timely fashion, Frank, to your point, I think, that's what we do strive for at the commission.
Is there ongoing discussion or anything in particular right now that you're looking at in the regs to actually implement some sort of streamlining process? Or is it also a question that you've bulked up on hiring, more inspectors, more agents, things of that nature? So
a couple of things. Let me unpack that a little bit. So Chapter 180 gives the commission added authority. So around your HCAs before, that was the beginning of the law. There were HCAs, but there was no oversight. So it was the Wild West. So now the commission has oversight over the HCAs. So that, as far as what we originally intended when we were drafting the regulations, the licensing, we all discussed a May 1st start date for the commission to review, approve, and certify your HCAs. It was going to be May 1st, but we heard from all of you. And a lot of you said that's too long, like we've been in this holding pattern, this purgatory for too long, what can you do? So because of staffing and because it is a major undertaking now to review these HCAs to make sure they're compliant, to call balls and strikes, we do need to make sure licensing has enough staff. But we moved it from May to March 1st. And that may not sound like a ton, but it is a ton. We got it to, so now starting March 1st, that the commission will review, approve, and certify these HCAs. That hadn't been done before. I read many of the HCAs out there, and quite frankly, I was aghast at some of the provisions that I was reading. When you can tell me why an ME would need to buy electric vehicles and charging stations and how that is reasonably related. If somebody can explain that to me, I'd be highly curious. But there were a lot of provisions, so we wanted to make sure we leveled the playing field. But the law was passed in November of 2022. And here we are, almost November of 2023. It is the law. So municipalities, need to follow the law, and we will start calling balls and strikes on March 1st.
So let's put some detail for the audience on the HCA host community agreements. You have to have one to get a license and operate in the Commonwealth. And before, it was, as you said, it was the Wild Wild West.
It was.
The statute was there, but in my opinion, cities and towns ignored it. And you did not have the enforcement by legislation, so there wasn't anything you could really do. And Steve and I used to have this argument all the time. And clients were abused through this process, buying the fire truck or donating to somebody's charity. And there was also 3%. They could charge you 3% of your gross, and it wasn't necessarily related to the actual cost. Can you give us an overview? I mean, there's a lot in there that you guys have done. A lot also is going to help social equity.
Right.
But can you give us an overview, particularly about the safeguards that you've now built in so that the towns can't do what they did before?
Right. So as I shared with all of you, I worked for the Sheriff's Department for over a decade. So I'm going to use a saying that I like. There's a new sheriff in town when it comes to HCAs, and there was no sheriff. So now, pardon your, if you're renewing, okay, part of the renewal in the anniversary of your final license date, you will need to submit a compliant HCA to us. For a new license, you will need to submit a compliant HCA between you and the municipality. Now, Frank, you said the 3%, right? That was there, but what was happening is nothing was demonstrated as either A, being reasonably related, or there was nothing itemized to show where the money went. And I know MEs that have already paid over $1 million, right, in community impact fees and can't get a receipt. Imagine that. You pay $1 million and you can't get a receipt for where your money went. So those days are done. So now there'll be an itemized receipt. And what you're doing is, before I've heard of towns, and we met with the MMA and we met with stakeholders, and we were hearing about upfront payments. Like, to even play ball in a town, you'd have to do an upfront payment to get to step foot in the town. And it was explained to me when these were first negotiated, and that it was basically, if the guy in front of you signed it, and if you don't sign it, the guy behind you or the gal behind you will sign it. So that really wasn't a level playing field, and quite frankly, from what Frank, what I read is that quite a few of these were contracts of adhesion. So now that's in regulation. There will be no more contracts of adhesion. There will be no undue duress or strong arming or coercion, no more upfront payments, no automatic 3%. That itemized bill will be due 30 days after the anniversary of your final license date, and it has to be reasonably related. And we made sure that we have a definition of reasonably related. What it is, it's a direct nexus between
demonstrable
nexus.
That'll be the next thing we figure out what that means.
Demonstrable nexus between the ME, the impacts of the ME doing business in the municipality, and how that creates an increased need for goods or services in that municipality. So it has to be reasonably rated. It can't be an automatic 3%. It can't be forced donations. It can't be forced in-kind donations. It has to be itemized, and it has to be on actual impacts that your business caused within that municipality. Now, what changed is it went from 5 years to 8 years now. So that's different, and that was, I guess, that's what
I read the regs 9 for some reason.
We did.
Yeah.
We get that question a lot.
Yeah.
So the legislature had put, after 8 years, that you will no longer have to pay those CIFs. They will sunset. But the reason we put 9 years in the regulations is because we're doing the year behind. So the year before. So on year 9, your last year you'll get paid was, through 9, right? Because you're paying now your CIFs, your community impact fees, for the impacts that your entity created in the year before. Does that make sense?
So 2 questions. You review when it comes for renewal, you review and license. Now, there are cities that are still taking very hard lines on this. So you have existing HCAs that are not in compliant, that aren't up for renewal yet.
Right.
What are you doing about those? Is the CCC going to review those? What if somebody has a complaint? Can they bring that to the CCC? We have tried to negotiate with a number of cities on this on behalf of clients, and some of them just can't get out of their own way, and they're playing hardball, and they're threatening, well, we just won't renew your license.
Okay, so yes, 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 yes. So basically, we're not calling balls and strikes till March 1st, but it is Chapter 180 is the law. So this might not be the answer you want, but it's the answer I have. You can seek relief in a court of competent jurisdiction in the meantime. And you know what? A number of MEs are doing that right now. There are court cases that are out there, around this.
So do you feel the cities are correct when they say, no, the statute is going forward, not going back, that the CC...
The law was signed by Governor Baker in November of 2022. It is the law. The statute also gave the commission 1 year to promulgate regulations, interpreting that legislation into regulation. So the law was the law in November of 2022.
Right, but some towns are still taking the position that it's the law, but it doesn't apply to existing HCAs.
We will review, certify, and approve.
Prior to review, they're taking that position.
Prior to review.
Yeah.
Okay.
There's a gap there.
So again, there's the court of competent jurisdiction. Yeah. We will field, I think you had said something about if someone files a complaint, the commission will review all complaints. In 500 in the regulations, there are avenues for a hearing if you feel aggrieved. As well, so that is an option. And then if there's an abrogation or separation, there's also an opportunity to be heard there as well. And we provided equitable relief provisions as well in the regulations.
So what happens when somebody comes to you for renewal, the HCA doesn't comply, and I've read the regs, it says you can prevent the issuance of the license, but if it's not the licensee's fault, they're being held up by the town, you're actually hurting them if the license isn't renewed. I'm assuming that you could do equitable relief and extend the license.
Yeah, so there's also what, and a lot of folks have been asking, Frank, is that model HCA, right? Everybody wants to see it. So we're pivoting. I want you to know we are pivoting to that model HCA right now. I'm on that working group. We hope to have that out sooner rather than later. And if I just may add, if anybody has an HCA that they feel is compliant with the new law, that there are best practices, send it our way. Send it to the commission's website, and we want to see if folks, because there are, I don't want to make them sound like they're all bad, because I have talked to MEs where they're happy with their HCA, and those we want to see. But equitable relief will be part of the factor, and we can't, Frank, we can't compel an HCA, we can't make a host community be a host community, right? We don't have the statutory authority to do that. But what we can say is you need to renegotiate or negotiate these renewals in good faith, and you can't exercise bad faith. So, and we have in statute things we can do. We can do sanctions. We can circulate, publish a list of host communities that are not friendly or compliant with the new law. So there are different things we can take, and we're still formulating the teeth on all of those.
So talk about a big element of the HCA regs is social equity, and trying to, as the Commonwealth has always tried to do, is create more social equity opportunities. Can you share with us, some of those components that are in the regs that really you're hoping will help social equity get more of a level playing field, so to speak? So
let's just back up. So Massachusetts was the first state in the country to mandate equity as part of the cannabis industry. So there was no other state that had that. And what did that look like? Well, that looked like providing technical assistance, waived fees, our social equity programs, and the different cohorts that have gone through. The legislature also had an opening enrollment period to become an economic empowerment applicant, and it was a very short window. And eventually 122 folks got designated as an EEA. So fast forward today, we've done a lot, but there's more work to do. So of the 122 EEAs, you have about 10% that are commenced operations. For the SEP, we're also at about 10%, which, okay, there's more work to do, but let's now fast forward. Now we have a municipal equity component that's law. We didn't have that back then. So maybe they couldn't get through the first step, which is negotiating with your municipality to even get to us, right? So that was probably a barrier to entry because there was no municipal equity in law, and there was no mandate to do it on the local level. There was for us for the commission, but there wasn't, and we had no jurisdiction. Remember, we had no jurisdiction over HCA's as well. So now we fast forward to Chapter 180, and it will be a high priority. And if municipalities don't take into account municipal equity, they can forfeit all of their CIFs, all of their community impact fees, if they ignore the municipal equity mandate that they need to do. We also put a provision in if a municipality raises that ceiling, that cap, that they should, it should be a 1-to-1. Now, in other words, so if they have 3 and if they go to 4, then, I'm sorry, if they add 2 more, then 1 needs to automatically go to equity and then 1 to a general applicant. So I raised the prospect though, what about a community like Peru, way out in Western Mass, and by no fault of their own, if they don't attract an equity candidate, should they be penalized? So we added something for communities in rural areas that maybe would not attract an equity candidate, that they can apply for a waiver around that. So, and also, as you know, part of your positive impact plan, you can satisfy it, right, with a donation to the Social Equity Fund. And I know we don't oversee the Social Equity Trust Fund, but I know folks on that board are working to stand up their regulations and stand up the way that folks can donate to there. But so there are a lot of things that weren't in place even just a few years ago that should help with municipal equity. We're also calling for transparency around the process. How are you scoring these candidates? How are you scoring equity? And so the entire process needs to be transparent. As far as also helping helping equity candidates negotiate the HCA, giving them time to negotiate, providing translators if necessary, giving them every opportunity to negotiate in good faith.
So let's stick with social equity outside the HCA.
Sure.
Talk about some other initiatives. The market is heavily saturated. It's tough to compete. Social equity candidates with 1, 2, 3 stores, it's tough to compete with the big boys because they like market share. Mm-hmm. And if they can't have multiple units, they become more aggressive. And a lot of social equity candidates have said, look, we can't exit the industry. We can't survive in it. We should be able to exit. The big MSOs have already hit their caps, the Rule 3 in Massachusetts. Mm-hmm. 3 medical, 3 adult. There is some initiatives to try to raise that cap. Obviously, it happens at the legislature, not at the commission, but I think it's important to hear the commission's or a commissioner's view on that. Mm-hmm. I have been advocating that this was coming for years, that I also think that the industry here may be ripe for a moratorium on the issuance of licenses. As anti-business as that may sound, sometimes you have to protect an industry. So what are your thoughts on that? Because there is a movement among social equity and MSOs to try to raise the cap in Massachusetts, an active one going on right now. Well,
the question is very apropos. We had this discussion today around delivery license type. As you know, that's an exclusive license type for equity. The clock started ticking on the commence operations of the first delivery operator, which was April Fool's Day of last year, no joke. So we talked about they have 2 licenses that they can have. So the commission is seriously discussing raising that ceiling to probably 3 for delivery operators as well.
The other issue, which was my second question, but you've jumped to it, is the 2-driver issue.
Right.
For the social equity wholesale delivery.
Sure.
Is highly problematic, highly expensive, and there's a dire need to get rid of the 2 drivers. And I think we're the only state, maybe there's one other state that requires 2 drivers.
So yes and no. So we're the only state for adult use that requires 2 drivers. Other states for medical use will have 2 drivers. So that I've heard from many stakeholders about the 2-to-1, and we're trying to say agents now, not drivers. 2 agents in the car. Former Commissioner Hoffman, I'm sure you can provide context, but I think the 2-agent rule was around public safety, right, and getting buy-in from from public safety officials to make sure that these deliveries were done in a safe and efficient manner. Having said that, I know it's costly, and we're aware of that, we're mindful of that, but last meeting on Thursday, we had a presentation from Director Kamalo, and she provided the commissioners with information we had heard for the first time. And that was that there was, since January of 2021, there were about 40 incidents ranging from motor vehicle accidents to a robbery, to theft, to diversion, crossing into state lines, delivering to federal housing, and there was, and then an agent being, I don't want to say held hostage, but held against their will during a delivery. That we were unaware of these 40 incidents. And so we're learning more about them. We had a meeting today, again, to revisit the driver delivery license. How do we make it more lucrative and more viable in Massachusetts? So what I asked for is can we separate the B2B? In other words, we have third-party transporters that do business to business, right? And they can carry much more product than the $10,000 allowed in the delivery, the adult use delivery. So let's look at if the incidents happen in the Brinks truck model, if you will, in the B2B, or was it to B2C, business to customer? So we're gonna delineate and see where those incidents are and look at them. And we're gonna look at other jurisdictions out west that have been delivering much longer than us to see how many incidents they've had when there's just one driver in the vehicle. So the answer is we're still discussing it and deliberating on it, but we're very mindful of it, and we want to make sure this license type is viable. We talked about repackaging today. Right now, delivery operators can white label, they cannot repackage, so that's up for debate. And then the no towns, right? So that's a big area.
Another question we wanted to ask you about.
So the no towns. And we're looking, our legal team right now is compiling information to bring back to the commissioners around what our authority is to dictate commerce in what's so-called a no town. So we are mindful of all of that.
So, you know, by way of example, there are alcohol delivery companies, Drizzly, who deliver to dry towns.
Correct.
So one could argue, what is the difference? Why shouldn't the wholesale delivery cannabis operators be able to deliver into those municipalities as well?
Well, we're going to look at other industries. It's not exactly apples to apples, but we are going to look at that.
From my seat it is, but.
We're going to look at that. We're going to look at other jurisdictions. And so we're going to revisit this in our November. Our teams told us today, our Director of Government Affairs and our Acting General Counsel, said they were able to bring us back that information for our November meeting.
So some of the, in the time we have left, some of the operational issues that our clients bring to us, and we actually polled a few of them. We said, look, we have the opportunity to meet with the commissioner. Tell us some of the issues that you're facing in your operations. Mm-hmm. And a couple common themes where love to get your comment on is advertising and billboards and concerns about, you know, legislature getting or limiting billboard ads, and also the fact that there are a lot of, I don't want to say a lot, there are dispensaries that are clearly violating the discount rules, and there are operators who are trying to play by those rules. So wanted to get your thoughts about if these are the kind of things that are coming in front of the board, and what your thoughts and how you're trying to deal with those.
Sure, and I didn't get a chance to, the question before about market saturation, you had mentioned, and I didn't
I'm glad, I want you to address how you feel about that.
And every month we go over, we have we call a pizza tracker, we track the licensees, and I asked months ago if we could add cultivation, and I always look at the square footage of what we have online, right, that has commenced operation, and then what's in the provisional stage, 1 million square feet of canopy right around the corner, and how does that impact an already oversaturated market? And we do have a tool at our disposal called relegation that if you don't sell or a certain percentage of your product, then you would get relegated down a tier. And I know many cultivators have reached out to us to start enforcing that relegation. We haven't done so. So that is an immediate tool at our disposal. Now, I'm not sitting here calling for a moratorium, but I am telling you I'm willing to look at what other states have done out west, more mature states, and I think some of them have done moratoriums on license types, and I think there's mixed results. So I'm open to hearing more, but I hear you. that there is a glutton of product. It's gluttonous right now in the industry. Now, consumers and patients love it, right? Because their price has plummeted considerably. But when you're a business person and you're working on small margins, it gets very difficult. So we are aware, and I am very mindful, and I do bring it up quite a bit, Frank. And I think we need to, if it gets to the point where it's a race to the bottom, and we need to really explore options.
I mean, yeah, it's great to have the top line, but if companies can't stay in business,
that's right.
It doesn't do any good for the
right.
Commonwealth. But and I appreciate your getting me back on track on this question. What about has there been any discussion at the commission level about raising the cap from like 3 to 6 or 3 to 10 number of units that people can own in the Commonwealth?
You mean like cultivation, other?
No,
I talked
dispensaries.
about delivery. Oh, dispensaries.
Yeah.
You know, we have not had that conversation as a body, as a board. So, I mean, maybe that's something. You know, I think the rule, and we all know why the rule was put in there, of 3, is so that there wasn't monopolies and there wasn't, so that the smaller mom and pop could have room in this industry and a space to grow. So we have to be mindful of unintended consequences when we do things like that. So we haven't had that discussion. It doesn't mean we won't have it, but someone would have to bring a really compelling reason and show that there is an unintended, that would hurt the people we're trying to help by doing that.
Well, if you have 400 dispensaries and you've got 6 units, it's a pretty small number. It's hard to argue that anyone would get a monopoly. You are going to hear, I think, a louder cry very soon, particularly from social equity owners, that they feel that they are boxed out from exiting the industry and capitalizing on their business.
I think that's more because they need 50.01. They need a certain amount of ownership and control for it to, like, in other words, if someone wants to come in and buy an equity business and the person who is the EEA or the SCP relinquishes that threshold, then that entity would no longer be
no longer
considered.
qualify, but
Yeah.
it's still an exit issue because the most likely buyers in this market are your MSOs.
Right.
And the large majority of MSOs in Massachusetts are capped out. They can only own 3. If you raise it to 6, you will start seeing more acquisitions.
Which I think,
Massachusetts.
if I am reading between the lines, it's trying to create generational wealth, and you really can't if you can't sell it.
Can't sell.
Yeah. Okay.
Well, not only that, you're in a down market. So some people need to get out before they
Right.
close their doors.
Right.
And you know, a number of operations have come to us on the restructuring, because we're in a restructuring mode here, and there's just a very small universe of buyers that have the ability to do so. So that's going to continue to be a pressing issue. But the last question I was asking was about
Billboards.
the advertising
Yeah,
and the discounts
Sure.
that you're not allowed to do on the
Right.
adult side, but clearly a lot of dispensaries are doing it.
Right. So let's talk about billboards first. And I sit in the public health seat, as I shared with you originally. And let me just first say that I believe in everyone's First Amendment rights. And I wouldn't want to do anything or impose any regulation that would infringe on that. But also, having said that there's regulations around disclaimers. And the way the regulations are written now, there's quite a bit of content that needs to go on a billboard, and it's not, in my opinion as an individual commissioner, it's not really practical because there's a lot. So Commissioner Stebbins and myself have looked at billboards a couple of times. He's kind of taken the lead on this now, and ideally if we could boil it down to please, consume safely and responsibly, and maybe one other. My gripe is that, and I understand why, there's so much content. It's not legible. We all know that. It's not, you need like a telescope to see these disclaimers. You can't see them. So how do we make it so that you have your First Amendment right to advertise, but we still put in the safety parameter that's realistic, and we're looking at that. We're exploring that now. We're meeting with billboard companies and to figure out how do we get to that happy medium. But did you have another question around billboards, or?
No, there was concern that legislature outside might be more restrictive. And billboards are a significant part of obviously marketing and promotion for dispensaries. It's very, very important. And if we lose that access to that media channel, it could have a negative impact.
So that, I can speak for one of 5. I can't foresee that happening in regulation. Now, what the legislature does, I have no say or jurisdiction over that. So that's for the legislature.
And then the other part of the question was, how are you dealing with the discounts?
It's funny you say that, Frank, because I noticed myself, right? So my mom is a certified medical patient, and I'm her certified caretaker. And so I'll go in and get her medication at a co-located facility. And we know that the medical side of the ledger is permitted to do discounts, but when I see it on the adult side, it does need to be addressed because it either needs to be allowed or enforced. And right now we're somewhere in the middle. And so we do need to revisit that, and we either need to permit it or prohibit it. And right now I think we're kind of in a loosey-goosey space, if you will.
Yeah. Just one last question, then I want to open it up. Are there any particular, like HCA was a priority item. Yep. And I do say this sincerely, kudos, and I know you spearheaded that, so congratulations.
Thank
and
you.
It's a huge improvement. There's no question about it. Are there any other, or maybe what is the next initiative, if there is one, that you feel needs to be addressed and changed?
Oh God, I got a lot of them, but I know you guys got a cocktail hour, so I won't keep you very long. But for me, micro businesses, that license type, I understand why it was set up. Minimal investment and easy to get into the market, but it's struggling. And I've met and visited many micro businesses. It's not thriving. One in my own backyard, if you will, is winding down operations. So that's another license type like delivery that this is an evolving industry. So as regulators, it's our job, right, to stay nimble and to look at what's working and what's not working. And micro businesses is not working. It's too restrictive. They can't get investors. So that's something that we're going to look at as well, along with the delivery. Myself, I've been a very vocal advocate around testing and what do we do about THC, potency inflation and lab shopping, and how do we ensure that products are safely tested? And for me, I think that starts with, we need to codify how you calculate potency and what it is, because right now there's 14 labs, and we don't have a standards lab or a reference lab in Massachusetts, and we don't have $5 million like this that we can build one. So what do we do in the process? Well, we absolutely need to make sure that our 14 ITLs are honest brokers and good stewards, and that folks aren't shopping around so they get their products passed. And we have an a la carte rule where you can send your microbials here and your potency here. Maybe we need to look at that a la carte rule. I think we inherited that from DPH. Maybe we need to revisit that. How about making all our metric data public? I think we could start there, right? Let's take all that metric data and all the testing data, because you guys could police the industry if all this data was at your fingertips. So that's a big, for me, in my individual capacity, testing, ensuring products are safely tested. And another individual priority of mine is research, because honestly, all of our futures, in the future of cannabis, I feel so directly to medical efficacy research. Think about a game changer if clinical studies are done and it shows that it's efficacy in XYZ comorbidity, or a major insurance company decides we're going to start covering cannabis. Think about that. That is such a game changer and a disruptor. I mean, acupuncture wasn't covered how many years ago, and now it is now. So I know former Chair Hoffman is working on bringing science and cannabis together. I am dedicated to bringing science and cannabis together because this plant is ancient. 10,000-year-old plant, and is in dire need of modern medicine research. And when we bring these two together, we're going to unfold the potential medicinal benefits of this plant as well as the harms. So those are my passions that I'm working on in regards to the cannabis industry, but I always listen to stakeholders, and feel free to email me, and I always take a meeting, and we need to hear from you, because you guys are on the ground floor, and grassroots, ground floor, and you know what the challenges are, probably even better than the regulators. So please let us know.
That's great. That's terrific. So I am going to open it up to just a couple questions. If anyone has, please feel free.
Roy, thank you very much, and thank you for all the work you're doing, and what a ride it's been.
Yep, it sure has.
There's been a rumor on the street that one operator has gone in front of the commission to convert over to an ESOP, employee-owned company. Is that true? If it is true, is there any opinions floating around the commission on that structure to help some of the companies survive?
So if they have appealed to the commission, it hasn't trickled down to the commissioners yet. So it hasn't been, I don't know if it's not ripe enough, it hasn't been brought to us. Now, what I am hearing is that entities are unionizing, and so I think one just did last week. So, and let me just say that worker safety is paramount. So when workers have a voice, it's incredibly important. We want to make sure that the 30,000 plus registered agents in the cannabis industry have a safe work environment. Now, this is a fairly new industry, and we don't know all the occupational hazards. And it's incumbent upon not only Massachusetts, but the entire nation. 3/4 of the nation has access, folks have access to cannabis on some, legal cannabis on some level. And some states have taken it upon themselves to study the cannabis dust, right? What happens, is there any occupational hazard with exposure to cannabis dust? We need to learn more, and employees need to know, and part of when we look at the post-provisional license inspections now, where I had asked for that the whistleblower policies be put in there, that employees know what the whistleblower policies are, and that they have that afforded to them, and it's it's law. So we want safers work at the end of the day, and the commission is dedicated to helping to see that through.
So I'll just add one comment to that. So, and one of our partners though, is Markham, Jill Scher, who I have tremendous respect for. You should talk to her at the cocktail party. The reason they're doing an ESOP, and this has been floated around for years, and most accountants say that it's nonsense, is they think they can get around 280E by forming an ESOP.
Oh, on the federal level?
Yes.
Oh.
So it's not
Okay.
the CCC should not have a concern whether you're using an LLC or a corporation. So that rumor, I think, is probably just, somebody's going front with an ESOP. But I'm putting Jill's on the spot. But every accounting firm I have spoken to and my own tax partners think that it's bullshit to get around 288. I'm going to put it that bluntly, but that's what that's all about.
So wait, so the ESOP, you're saying cannot get around 288?
There are certain lawyers, and I will say tax lawyers, that are arguing that if you do an ESOP, that you are not subject to 280E.
Oh.
Okay. And nobody that I'm aware of, has done this yet successfully. But I will let Jill talk during cocktail hour.
That's
over
interesting.
That. Yes, please.
Well, thank you for all you do. Can you talk a little, we hear so much negative lately, but can you talk a little bit more about one of your successes in moving Massachusetts as a pioneer in educating our teenagers?
Oh, yeah. Thank you, Dr.
on
Valenti.
driving?
Yeah.
And I am occasionally hearing of other states.
Thank you.
Can you say that that's been shared?
Sure, and thank you for that question, Dr. Valenti, and thank you for your research and your work around detecting impairment. So when I first became a commissioner, and literally day one getting sworn in Governor Baker's office, someone had recently brought to my attention right before that Massachusetts, and quite frankly, there was no states that were teaching young people in the driving school around cannabis impairment. And I'm not talking the DARE program and Unscared Straight, none of that, but just evidence-based information that if you feel different, you drive different, because social media was creating norms out there. So I said, I'm going to fix this. I'm determined. So I convened with Commissioner Stebbins a working group with AAA Northeast, and we had folks from DPH, and we had folks from the RMV, MassDOT, and we had a researcher from UMass, Dr. Whitehill, and AAA had a curriculum already built for health classes in Rhode Island called Shifting Gears, the Blunt Truth About Marijuana. So what we did was we adopted and adapted that from Massachusetts and Massachusetts laws. And it's evidence-based, it's less than a 30-minute video, and that if you feel different, you drive different, recognize the signs of impairment. Now, we're not telling you, we're not stigmatizing anything. We're not telling you to do this or do that. We're telling young people that if you do consume and if you feel different, recognize those signs. So we want you safe and everyone else safe. So last December, myself, former Lieutenant Governor Karen Polito, and Colleen Ogilvie, the RMV, director of the RMV registrar, we announced that Massachusetts was the first state in the country to adopt this, mandated in every driving school. 60,000 students a year will see this curriculum, and since then Rhode Island passed a law, Connecticut passed a law, Maine's going to the process of, and like a dozen other states are following our lead, just to give young people the education that in evidence-based. And we also had a local high school, Keefe Technical High School in Framingham. The senior class did a project, and what they did was they went through every social media platform, from TikTok to YouTube to Instagram, to see what the messages were. And they were basically glamorizing impaired driving, that you drive safer, you drive slower. So we wanted to get the right information to young people, so thank you for that, Dr. Valente. I'm really proud of that, and Massachusetts once again takes the lead.
One last question, and then we hit the bar. Yes.
Thank you very much for taking the time to be here.
Sure.
One question I had, though, was in terms of relegation as well as remediated product. We hear a lot of rumors in this industry, and it appears that a lot of those big giant tiers that aren't making that square footage requirements, or they're underproducing. A lot of those that are starting to work in those spaces, those are the ones that have to go through the remediation process where the product may be contaminated with mold and mildew, things of that nature. What's your opinion? What is the cannabis controls contained in regards to remediating product and the health concern that may have on the public?
Sure, thank you for that question. And I am open to exploring that, whether it's rad source or ozone. If product is remediated, radiated, maybe consumers need to know that. Now, some say, well, half your vegetables in the produce aisle were that, and there's no labels on that. So we need to hear both sides of the argument on that. And I hope there isn't selective batching, if you will, and sent to the labs. I know that's a concern as well. Some states, the labs go and get the batch themselves to be tested. In Massachusetts, that's not the case, and maybe we need to look at that the lab goes and gets the batch so we can ensure it's an accurate depiction of the entire batch. But I am curious to learn more about that. I believe Nevada is the first state to disclose whether products have been remediated in radiation or ozone. So I'm open to that, but I'm one of 5.
Well, I want to thank Commissioner Roy for daring to go where others in your department didn't. No, in all seriousness, you're doing a terrific job. We appreciate that. The HCA is very important to this industry, the changes that you've spearheaded at the commission level. I reiterate, and that there are concerns about the operation of the commission. Hopefully that will get sorted out quickly, but there are advances happening. There are other issues confronting us, and hopefully in time the commission will stay focused and address those for the industry. So thank you for being here.
Thank you, Frank, for having me.
And I want to thank everybody, especially everyone in this room, for lasting it out this long.
I know.
That means the bar is really an open bar, and it's open. So thank you very much.
Yeah, thank you, Frank. Thank you.
Really appreciate it.
You're welcome.
Really, thank you.